I worked on the Casey Anthony case, and that was almost more emotional and visceral for a lot of the jurors that came into that than even the O.J. Simpson case. This storm of media actually worked to the disadvantage of the prosecution. The fact that a young mother was being accused of killing her own child, something so primal about that.
Welcome to another episode of Courtside Convo. I'm really pleased to have with us today Richard Gabriel, who is the president of Decision Analysis Incorporated. He is a jury consultant. He's an expert in that field and has been a pioneer and also an author, having written 2 books about the legal field and some of the cases that he's been involved in. Richard, welcome to the show.
Thanks, Dan.
So let's start at the beginning. How did you get into this crazy business?
So I'm asked this question a lot, and my easiest answer is that my mother's a judge, my dad was a psychologist, and I trained in the theater. So all of those things ended up combining into a particular set of skills, I think, that kind of inevitably led me into the field. I was teaching communication courses through a university. Some lawyers showed up in my classes. They asked me to come work with some witnesses. They asked me then to work on some trials, and here I am 41 years later.
Gotcha. So, given all that background, what is your core business now? What are the things that you're focused on and working on?
So we're a pretty broad range trial consulting company. Our services obviously include doing a lot of focus groups and mock trials. We do a lot of witness preparation. We do a lot of jury selections these days. But more and more, we are spending time really focusing on how attorneys tell the story of the case. So we do a lot of work in terms of developing themes. We spend a lot of time really trying to figure out what is the actual story? Because a lot of times what happens in cases is the attorneys work up the thing from a legal standpoint, which is understandable. But sometimes it's not what I would call a jury story. In other words, it's not something that a lay people go, all right, here's what would help me to understand, especially the case, especially when it's a complex case that involves patents or securities or significant injuries.
Yeah, they get caught up in sort of the minutia or the legalities, and they forget to tell a good story.
Yeah, and I mean that's it's called it's the detriment of knowledge that attorneys bring after months, if not years, of working up a case. They're incredibly knowledgeable, and they sometimes forget how a layperson is hearing this case for the first time. And so simplifying the case, giving enough context or background to the case in order to better understand why the actions led to it. And a lot of times, we talk about storytelling a lot. And a lot of times in a case, it moves to what happened. But oftentimes the jury doesn't know what's the world in which the plaintiff is living in or the defense is living in. You have a medical malpractice case, they start with what happened in the surgery, but they don't understand the background of the plaintiff and what kind of problems they had, their medical history, or literally how a hospital is run, how a surgical procedure actually happens. So a lot of times all that background gets sort of shoved to the back of it, and the sequence of what jurors need to know at various points in the case also gets rearranged, sometimes based on the trial schedule, when witnesses are available. And so they're getting these sort of piece of the case in very disjointed fashion. And we're trying to help the attorneys really fashion a cohesive story that the jurors obviously makes more sense to them than the other side's story.
Speaking of telling stories, you have been involved in some of the biggest stories in the American legal system, certainly in the last 50 years. O.J. Simpson, it's got to be at the top of the list in terms of notoriety. Um, how do you, or I want to ask you, what's the environment like inside those, literal storms of media, PR coverage, social media, et cetera?
It's it's madness is what it is. I mean, it is crazy. It throws everything on its head of what you would normally think in a legal case. Because let's face it, jurors are supposed to come to a case impartial. They're supposed to be indifferent to this. They're not supposed to have a vast amount of knowledge of the case. And when you're in this media environment, jurors are preconditioned by a tremendous amount of stories and public uprising and public sentiment prior to them actually showing up in court. And as a result, you have to employ very, very different jury selection strategies. You have to have a whole media strategy as to how you're dealing with it. And then you have to have a better understanding of how you present your case in trial.
So, are you able to determine, during the selection process, who's going to kind of be immune or less susceptible to just following along with those storylines they might have already seen, whether it's media, social media, et cetera?
Well, yes. I mean, you're asking questions about not only what they've heard and seen on the news, but also you're finding out how it's affected them. And that's the important part, is to really have a better understanding of, oh my gosh, not only did I see this story, but this is what I concluded as a result of that. Like, yeah, I worked on the Casey Anthony case, and that was almost more emotional and visceral for a lot of the jurors that came into that than even the O.J. Simpson case, partly because it's such an important issue for so many people. The fact that a young mother was being accused of killing her own child, something so primal about that, that not only understanding how people felt, what they seen, but also how they felt about the issues in the case was really, really important. I will tell you this though, you know, it is important to better understand how jurors have been affected by it, but jurors are also pretty amazing at understanding that the media has a point of view. And once they get into trial, they take their jobs really seriously and sometimes can listen to the evidence anew and kind of go, wow, I never knew this. This was not something that Nancy Grace said or that we did it. And so they will have a better understanding of actually what they're hearing in court. And to a certain extent, we found this out during the Casey Anthony case, this storm of media publicity that happened before that case actually worked to the disadvantage of the prosecution because jurors in Florida they have this thing called the Sunshine Law, which basically means that every piece of information that's exchanged between the defense and the prosecution is public. So the jurors had already known exactly what the prosecution was going to be presenting, and there was nothing new when they heard that. And all of a sudden, when we came in there, we talked a little bit about, you know, Casey Anthony's relationship with her father and the abuse and the fact that, Kaylee had drowned. All of a sudden, that was new information, had more salience, had a little bit more persuasive power because it was new. So
News story.
the media can create also unrealistic expectations for both sides. So that's another thing you have to understand about media.
In terms of that aspect of it, what's the most sort of egregious, out of bounds thing that you saw or heard during all these cases that was just, complete fabrication? That's probably too
You know,
hard of a question. There's so many.
there's not one thing that sort of sticks out in my mind. The problem is that there are so many opinions out there. It's not necessarily that there's falsehoods. There are that, but the problem is that these cases are not just reports of what's going on in the case. They typically favor the prosecution because all the information that's in the media typically is what the prosecution is alleging against the defendant. And the defense in a criminal case often keeps their defenses very close to their vest. And so they don't have that. So all they're hearing that, and then they're hearing on top of that, especially with the advent of vast amounts of podcasts and bloggers and there's just so much opinion that is out there, which is informing how people should feel about the evidence. So, in that light, all of a sudden it's harder for jurors to truly keep an open mind when they've been exposed to so many, not only pieces of information that favor the prosecution, but also opinions about that evidence.
Yeah. So when people are, when you're in voir dire with jurors, I'm sure it's difficult just to kind of get past that surface level um, guard that they have up. How do you do that and really, dig into their true feelings? Is it possible during a process like that?
Yeah, it is possible, but there's a particular set of skills that attorneys have to bring to it. The problem is most attorneys are trained in examination skills, either during deposition or in trial. And as a result, it's very difficult for them to have a very natural conversation in court with jurors to kind of just ask these broad general questions. How do you feel about this? How do you think about this? That's the most informed information I can get from a jury as opposed to close-ended questions or would you agree leading questions that is very easy for attorneys to so just putting jurors at ease is something that's very important in the process. Getting them to feel like, okay, let's just talk about this stuff. Because then we also have this big kind of highlighted sign about bias that's in every jury selection, which is, everybody's trying to figure out with somebody, no one wants to admit they're biased about issues. But if we just spend more time in court talking to people about their life experiences, their beliefs, their thoughts, about how they expect stuff, their worldview, all of that, it will give us much better information to actually make decisions about a jury.
What's the role, of credibility, the attorney's credibility, and how do they establish that with the jury, right off the bat and, get that trust?
Well, one of the things I like to talk to attorneys about is really how do you define your role? Because a lot of attorneys do think their job is to persuade the jury. I'm here to convince you that my side is right. The problem is that we are such sophisticated and skeptical consumers of information these days that anybody who has any vestige of is trying to convince us of something, we're going to automatically be resistant to. So for the most part, it's harder to convince attorneys to just take a more neutral position and to say, we are here to help you, the jury, to better understand this case so that you can make the most informed decision and verdict in this case. Because the stronger you get, the less credibility you have, the more resistance the jury has to you, the less credibility you have. So the more that you can say, kind of virtually put your arm around their shoulders and say, let's walk through this case together. We'll present what we think is kind of the stuff that's important to you, but ultimately it's up to you to make the best decision you can in the case. That is giving power over to the jury. That by itself is credibility.
With that goes along with presentation. We talked about it before we started here, how important presenting evidence and making it make sense to the layman is. So how important is that in your, in your work today, but just overall making a believable, credible, and excellent presentation to a jury?
Well, it's another sore point with me because attorneys are usually not taught in law school about great presentation skills. The mock trial programs are kind of fairly scarce. There's not that many attorneys that participate in them. And those attorney presentation skills are so important for anybody who's a litigator because they sometimes have to just be in front of a judge or a mediator. They have to present. And being able to tell a story, being able to use great graphics and visuals and demonstratives to tell that story, being animated, having some energy, understanding eye contact and vocal tone and variance and just the dynamics of presentation is critically important because it's not just the message, it's the messenger that is being judged in terms of the credibility of the evidence and the arguments that are being made.
Do you look for nonverbal cues, body language, things like that? Can you pick up those things, let's say, when a crucial piece of evidence, hits the screen for the first time? And I'm guessing you also do this, in advance too, in mock juries and focus groups.
Yeah, I mean, I'm probably a little more sophisticated than a lot of people in the body language, but it's really funny. The research is pretty clear that we're all pretty bad at reading body language. So,
It's not body language so much as, well, what is it?
so what it is first of all, you have to understand what's the baseline body language of a juror. Because if somebody's naturally skeptical or they're just thinking, they can be sitting there with a scowl on their face when actually they're just concentrating. So interpreting what that body language is really important. But what's actually much more critical than trying to read these mysterious signals is just presenting information in a way that you know is going to get a good reaction. The body language obviously is very important in jury selection. And for me, it's just asking really good quality information so that you're getting honest, candid responses from a juror. And then you don't have to spend a lot of that mysterious voodoo, you know, crystal ball type stuff where you're trying to interpret these subtle signs of whether somebody likes something or not. It's asking good questions, getting people to be as candid as possible so that they're they're in sync with both their verbal and nonverbal responses.
That makes a ton of sense. How has the post-COVID move to a lot of virtual litigation, whether it's depositions or what have you, but certainly people are appearing in court now virtually and using tools like Zoom. So how has that changed, the industry, what you do, and how you do it?
Well, I think it's changed it for the better. As a matter of fact, during COVID, I founded a project called the Online Courtroom Project, where I said, look, we've got the Sixth and Seventh Amendment, but the courts are all shut down. So the court is itself a verbal rhetorical forum, which for the most part can be done virtually. You and I are speaking that way now, and we're just communicating just fine. And there's lots of tools that can be used on Zoom and other platforms to show visual evidence, to have a witness there. We found when we did research on this that actually jurors found it easier to judge credibility of witnesses because they're right there. They're not, 20 feet away or 30 feet away. They're literally on the screen in front of them. And there is some loss in terms of some of that in-court experience of it. But that being said, the actual communication of evidence and even jury selection to this point, King County still is doing online jury selections these days, and they're finding that they're getting more representative jurors because more representative pools because people feel more comfortable appearing virtually as opposed to having to drive all the way down to the courthouse. And so there's lots of advantages for witnesses to testify virtually and not having to do a bunch of rescheduling on stuff. There's lots of advantages to at least employing greater online tools these days. We're doing a lot of jury research projects still online, and we find the quality is very good. Recently, there was a study that came out, which they started during COVID with Valerie Hans, and I'm trying to remember the other researcher's name, but they found that actually the decision making of jurors is very similar on both virtual trials as well as online trials.
Virtual versus in person. You're
Virtual
getting similar
versus in
results.
person, they
Yeah.
found that the decision making was very similar, and if in some respects enhanced by the online presentation of evidence.
Well, that's really interesting. So, how were they enhanced? How are they, how are they better or in some other way?
Oftentimes, visually they can see stuff much closer. It's literally right on the screen in front of them. Um, they feel more comfortable. They're in their own natural environment. Um, there's just a number of things we found when we did projects during that time that found sort of the enhancements of people's general comfort level. And the representativeness is kind of an important point these days too. Um,
Yeah.
Especially people of color are reluctant to go down to a courthouse because especially these days, there's a lot of discussion about immigration issues.
Yeah.
A lot of people just don't show up for jury service. So there's just more comfort level when they're in their own home that somehow, and also the formality and sometimes the intimidation factor of being
Right.
in a courtroom also makes it difficult for some jurors to do it. It's
Yeah.
just
That's really interesting. So, do you think that there's going to be maybe a move, given that research, you think there's possibly a move toward actually increasing virtual participation in formal legal proceedings?
I think there's I think there's more of a move in formal legal proceedings. A lot I see now in court is I do see a lot of motion practice, a lot of pretrial that's being done by Zoom and stuff like that. So courts are obviously much more comfortable with hearing stuff. Here's motions, here's things that are, pretrial hearings, things like that, that are happening virtually. That's obviously very convenient. The courts are still pretty um,
Archaic, maybe,
reluctant.
yeah, but just
They are, it's a
it's
very
a
old
like big
model.
ship turns slow kind of thing, right?
It's I call it turning the tanker, where you're just they're very slow to employ that. There's a lot of people who just think, and well, let's face it, there's a big courtroom staff and stuff like that. But I do believe there's lots of advantages. People who are in rural districts sometimes have to drive hundreds of miles to get to a court. So there's all kinds of convenience factors and things that I think can be enhanced by more virtual consideration of trial practices.
When you do your mock juries and trial prep that way, do you do them exclusively virtual? Do you still have clients that want you to travel to whatever locale they're in?
We we still do mock trials in person for the most part. We do a lot of focus groups online. We find that works really well. We do a lot of our witness preparations online, and a lot of consultations with counsel who are doing all over the country. Those are all done online and very, very convenient. You're not spending a ton of time on an airplane or in an airport or on the road, and it's cost effective for clients as well. And it's also just more convenient and it's more efficient.
Yeah, absolutely. So I wanted to ask you about witness prep. What are some of those things that you key in on? How do you get somebody that may be completely inexperienced? So you talked about intimidation factor earlier. Certainly, that could be very high for a witness coming into a courtroom, a completely unfamiliar environment. So how do you get them prepared to testify, or even if it's just in a deposition setting? How do you get them prepped?
Well, a lot of times, we spend time with our witnesses because unfortunately, th- they often have a bunch of assumptions and anxiety about testifying as a witness. I mean, unless, of course, they're an expert. But for the most part, so it's how do we help them to be more confident? How do we give them the skills to listen better and to respond most accurately to the questions that they're getting? And so it's because it's a foreign environment. Such a different thing. So getting them oriented toward the question, getting them out of the way of whatever baggage they have that's going to get in the way of them being as honest, truthful, and accurate as possible is the psychology of witness preparation. It's better understanding what's getting in the way there. What are you anxious about? What are you what are you worried about here? And then how then can you accurately listen to what exactly you're being asked?
Do you find that there's one particular hurdle that most people have to get over? Is there one thing that comes up most often when you dig in there?
I don't know if there's one thing. I mean,
Just a
it
general,
is
just a general.
well, probably the most general thing is a lot of times the witness thinks they have to answer the exact question as posed. And we all know that when especially you're being deposed or being cross-examined, or even sometimes in direct examination, what we are trying to do in witness preparation is trying to get at the witness's own truth, which sometimes is affected by sometimes what their own attorney is telling them they want them to say, or the framework in which the opposing counsel is trying to frame the question, or their own anxiety about what they think they should be answering there. So it's trying to clear all that stuff out to try and better understand, here's the issue that you're being asked about. What's your honest to God answer for that? And getting that thing, because the problem is a lot of the witnesses, their stuff sounds very canned. When they get prepared, a lot of times the attorneys load them up with a lot of things they want them to say, as opposed to really finding out from them, what's the truth? What's for them the best way of doing it? And that's the way to witness credibility, is to really, honest to God, find out how a witness feels about a particular issue they're being asked about in their own words, and how to work with that.
Well, Richard, if people want to reach you, your company, bring you on to consult with them, or any of the services that you provide, what's the best way for them to reach you?
So you can email me at rgabriel@decisionanalysisinc.com. Decision Analysis Inc. is our website. You can take a look at that. If you're interested in the projects I've done, there's the online courtroom project.org. There's the Trust in Justice project.org. And we've recently done this pretty remarkable study called The Rule of Law, in which we did a national poll and did 6 focus groups to find out how the American people feel about the Constitution, democracy, and the role of government. So there's all kinds of ways that you can find out about a lot of the projects or about us as a company.
Well, thank you so much for being on Courtside Convo today. It was fascinating to hear all your insights and expertise from the cases that you worked over the years. We really appreciate the time, and thanks again.
Thank you, Dan. Take care.
If you'd like to appear on Courtside Convo, send us an email or visit us at legalgraphicworks.com. Look for new episodes every Thursday on the Legal Graphic Works YouTube channel, and don't forget to like and subscribe so you never miss a show. Thanks for watching.